Hello there, I'm Lucy Whitaker. I'm a specialist motoring solicitor, and this short video is about special reasons in driving offence cases. So, what are special reasons? I'll explain by giving you some examples in a minute, but the significance of special reasons are that they allow the court not to disqualify you from an offence which would ordinarily carry a mandatory disqualification. Similarly, in cases which ordinarily carry penalty points, if special reasons are found, it allows the court not to impose those points. For these reasons, special reasons are extremely useful, and in a way they bridge the gap between a full acquittal, i.e. a finding of not guilty, and a straightforward guilty plea. In layman's terms, the best way I can describe special reasons is that it is similar to saying, I'm technically guilty of the offence, but there's an extremely good reason why I committed it, and it would be unfair to impose the usual punishment. So to illustrate that, let's take the offence of driving without insurance. Upon conviction for driving without insurance, the court must impose between 6 and 8 penalty points or a discretionary disqualification. Driving without insurance is generally known as a strict liability offence, and this means it doesn't matter whether you knew you were committing the offence. All that matters is whether you had a valid insurance policy at the time you drove your vehicle. This means that if, for example, you drive a vehicle, perhaps owned by your partner, and they're responsible for organising and paying for the insurance, but they forget to pay it, and you are stopped by the police for driving without insurance, you will not have a defence to the allegation. What you may well have is a special reason. It's up to the court whether the circumstances are such that you should avoid penalty points. So the minimum legal criteria which are required for special reasons arguments are that it must be a mitigating or extenuating circumstance, it must not amount in law to a defence, it must be directly connected with the commission of the offence, and it must be one which the court ought properly to take into consideration when imposing sentence. Now these are minimum criteria, and there are other factors to be taken into account by the court. The law in this area is extensive and I can't cover it all in a short video. I'll also do a short separate video specifically about special reasons in drink and drug driving cases, but this is merely an overview which may give you an indication of whether you could have a special reasons argument. So other examples of special reasons can include shortness of distance driven, if you drove a short distance, unlikely to be brought into contact with other road users, if you'd been misled without negligence, such as in the example I gave you with the insurance, or possibly even if a speed limit sign was obscured, which prevented you from seeing it. Emergencies are another one, but depending on the nature of them, they can also amount to a defence. For this, the court should apply an objective test to consider whether the driving was proportionate to the emergency in question. Factors that can't amount to special reasons are ones generally that are not in relation to the commission of the offence. So, for example, the impact of a disqualification on you or your family, or if the offence was relatively minor, those cannot be special reasons in themselves, that it's got to be related to why the offence was committed. If, having listened to this short video, you would like further advice or need court representation, please don't hesitate to get in touch with me using the details on the screen. Thank you for listening.